Hello everyone and welcome to this WISE session on navigating contract law for startups, a litigator's guide. My name is Jake Gatley. I'm a senior solicitor specialising in commercial and construction disputes, and I'm joined with my colleague Ed Jones, who's a legal director and who specialises in property and commercial disputes.
For those not already familiar with our firm, we're a highly rated full service law firm in the Southeast. We act for a wide range of different clients, from PLCs to startups across the country. In addition to our headquarters in Farnborough, we have offices in London, Reading and Ascot.
Some of you may already be familiar with our firm and the WISE series. In addition to offering free office space here in Farnborough, we want to try and share our knowledge with you by hosting these sessions so that we can engage with entrepreneurs and startups. And if you would like to speak to us about using our free workspaces, please do get in touch after the session.
So what will we be covering today? Jake will first of all take you through some tips and advice before entering into a contract. We will cover founders and shareholders agreements and things to consider when contracting with clients and customers. Then we will move on to navigating contractual disputes once a contract is signed. And I will then take you through the key considerations for startups when dealing with commercial lease disputes. It might seem strange that we're trying to put you off or avoid you having disputes in the first place, which may mean less work for us lawyers, but we do genuinely want to try and help you. And the hope is that this presentation will allow you to avoid some of the pitfalls of contractual disputes that you might find as you grow your business. So without further ado, I'll hand you over to Jake.
Thanks, Ed. So firstly, we're just going to have a recap of what is a contract. I say it's a recap because earlier in the year, there was a dedicated WISE session by one of my colleagues in the commercial team, which I highly recommend you go and check out. So to give you an overview then, a contract is a legally binding promise. It can be written or oral. There's a misconception it has to be in writing. That's not always the case. And there are four key elements, all of which could be dedicated presentations of themselves, but to just give a brief overview, there needs to be an offer, there needs to be an acceptance of that offer, there needs to be some form of consideration, and there needs to be an intention to create legal relations. So we understand that legal services can be expensive, money can be tight, especially when you're a startup. But from our experience, the legal risks for startups kick in at a very early stage of the business life cycle, and there are certain things you could do to make sure you're on a solid footing from the outset. The first tip from us to you is to put in place a founders and or shareholders agreement. So just to imagine you've got this £1 million idea that you've created with your business partner, and things are going great. And when things are going great, often problems don't always come to the surface. But when things may be not so great and they go south, then it can create time-consuming and expensive legal issues. By putting in place a well thought out agreement, it can help you mitigate those risks and save you a ton of headaches down the line, potentially, not to mention trying to avoid chalking up hefty legal fees. So just to move on to the main substantive bit of this slide, we're just going to cover a few things to consider when drawing up your own founders agreement. The first one being, do you have an aligned vision? A good place to start is to agree on the overall goal and vision of the business. If you can't agree on where the business is heading and what your aspirations are, then arguably there's no point in continuing. Do you want to revolutionize an industry? Do you want to change the way something is done? Maximize the profit on an existing business concept? It's important to agree on the why, what, and when, where and how from the outset. Next, how big is your share? Quite often it's the case that the default position is that you have an equal split among founding shareholders, but you have to ask yourself, does that reflect the reality? Each founder will bring their own expertise, whether it's technical abilities, they might have some contacts, they might have brought some assets or things that are useful for the business. And so it's good to have an honest conversation from the off so that you can allocate a value for each skill that each founder is bringing to the table. You may even consider having a vesting structure where if certain goals or certain things are achieved, then you will gain a certain percentage of shares when you reach a milestone. Number 3, who does what and what do you bring to the table? It's really good to define your roles clearly and set performance targets based on those roles. It means that everyone's held accountable, and also founders may also be required to contribute cash or assets into the business. 4, if someone leaves, what happens? It's always good to be prepared for someone's exit, including your own. Should that co-founder's piece be split up evenly between existing shareholders or co-founders, maybe there should be a right of first refusal for those shares. If that's not the case, if that is the case, how much should a co-founder pay for those shares? These are some of the issues for you to think about. 5, how will you be compensated? Dividend payments for startups can happen, and there could be good tax reasons for why that is. But if you're not going to do payments via dividends, then it's good to be clear about remuneration or salary that each person's going to receive, so that and if it's contingent on any targets being met as well, it's really good to be clear about that from the get-go. 6, day-to-day decisions versus reserve matters. The day-to-day decisions will likely be made by a designated CEO. However, where there's significant risk or direction of where the company's going to go, then you may want it so that it's mandated a certain number of shareholders need to be involved with a certain decision, which is sometimes called a reserve matter. So a good example of that is when you're selling the company itself, perhaps, or you're selling a particular asset, or maybe taking out a substantive loan for the company. It's really useful to think what decisions you want to be carved out for the reserve matters and the ones where you can leave to CEO to run the business on a day-to-day basis. And number 7, breakups can happen. This is a sensitive topic for obvious reasons. If there's unsolvable internal conflicts, then it's good to think down the line of how might you resolve those, and are you going to put a mechanism in your agreement to potentially resolve it? So a good common example of that is that you might have it so that the parties attend mediation to see if they can navigate through the disputes. And as part of that sort of discussion, you may also want to think about if someone leaves, are they allowed to keep their shareholding? It's not something, we see it on a lot of our company disputes, not a lot of thoughts given to it, and you can have a fight about what's going to happen to those shares when someone or several people leave. So just to recap, it's good to lay down a clear framework for the collaboration with your business partners. That's absolutely crucial. Strongly advise speaking to a legal professional about setting up a founders agreement, as it documents and delineates roles, responsibilities, the equity distribution and decision-making processes. Just to share with you, a recent experience we've had. We acted for a client whereby they had fallen out with the other two company directors and shareholders. They wanted to exit the company and take with them this intellectual property, which they say they created, and it belonged to them. But in short, it was really difficult to offer any positive legal solution because there wasn't a tailored shareholders agreement that reflected the various contributions to the company, including our clients. And in the end, the IP was retained by the company. There was little they could do about seeking payment for their shares, and this just underlines why this having a good foundation at the beginning can save you a ton of problems. Wasting time fighting with co-founders is a sure way to sink your startup, so we strongly suggest having some form of agreement in place. Next is our selection of top tips and considerations when working without a written contract. Firstly, it's useful to clarify the commercial relationship sooner rather than later and know what terms have been agreed. It can be really useful to draw up what we call a heads of terms document, so it clearly summarizes what you're going to be achieving, the key terms, and that you intend to formalize the agreement, and only by entering into a signed written contract will the agreement be legally binding. 2, make sure you enter into a written contract which includes an entire agreement clause. An entire agreement clause is designed so that all the arrangements that are agreed between the parties are in the single document and nothing more. It's important to include, for example, a job specification perhaps, or a delivery schedule with the agreement. It should prompt the parties to make sure everything that is needed to carry out the contract is included. Next, if you do exchange emails, mark them subject to contract. If you're in the throes of negotiating terms or you're about to draw up and sign a written contract, make sure your emails are marked subject to contract. This means it is less likely for parties to misinterpret or misunderstand the stage of the negotiations, and that you've not yet entered into a legally binding contract. One of the quite common disputes that comes across our desks are breach of contract and misrepresentation claims, and even in this day and age, it's surprising how many handshake agreements there are, things not being recorded. So it's super important to make sure that not only is it's in writing, but it is marked subject to contract as well. Next, have your key standard T's and C's prepared and audited. The potential to save time and money by having well-drafted terms and conditions from the outset is considerable. While every business is different, and it means that you will need something tailored to your business, having that quality legal advice from the outset can help you identify the potential risks and help you avoid them. Next, be mindful of any ad hoc correspondence and oral statements you might make when in negotiations, as they could bind the business. Even the most straightforward contract queries from a party can have unforeseen consequences. So if you get that last minute phone call, perhaps it's often a good idea to explain that you intend to confirm the outcome of that discussion in writing, and when you do so, it is headed subject to contract. This is particularly important if you are proposing to vary or amend the terms of the agreement, and it might be that the contract allows for certain changes to occur. And lastly, it is worth thinking about whether there is sufficient consideration for both sides to an agreement, or in other words, enough of a bargain between the parties, so as to try and avoid a potential dispute down the line, especially if it's a discussion as to whether there was sufficient consideration in the contract. You may want to have what we call token consideration, which might be just £1, or you might need to execute the agreement as a deed, which means consideration isn't needed in order for it to be legally binding. But if you have any concerns regarding this or any of the points on the slide that I've discussed, then please do get in touch. This next section is regarding what I've aptly called clause and effect, key potential provisions. So you've prepared the contract, you've got the deal over the line. What terms should you look out for in the contract if there is a dispute or a potential dispute? We will briefly highlight some of the key contract terms which may be relevant to you, and that may assist when considering the next steps and hopefully give you some sort of prompts to try and resolve the dispute. The first one is, are the goods and services defined? Is it clear what the deliverables are and how they will be measured? Second, is there an entire agreement clause? If so, what documents have been annexed to the agreement? Does the contract make reference to any external documents not included with the agreement? These all might be relevant. Number three, we've got limitation of liability. So is there a limitation of liability clause? It's not uncommon for a contract to be limited to the amount of the liability is limited to the value of the contract. But is there any carve out or exception to this? Is the dispute covered by this type of clause? Next is force majeure. So do you have a force majeure clause? A force majeure clause is designed to cover any uncontrollable events such as war, pandemics, strike action, extreme weather, even perhaps cyber attacks. So events that are not the fault of any party and that make it difficult or impossible to carry out normal business. You want to think, is it a force majeure event if there's a problem? And if so, is there a way to overcome the problem even if no party is liable to the other? Next, notices. It's worth looking in the contract to see what it says about communications, where any notices need to be sent, set out where it sets out the who, when, and what correspondence should be sent. Does this relate to payment, perhaps, or disputes under the contract, or does it maybe relate to quite specific events such as suspension or termination? Next, insurance. So does the contract say anything about insurance policies that should be in place, and what happens when parties are perhaps to pay under that insurance, and who's to provide that insurance? What happens when a party needs to make an insurance claim? Is there an insurance settlement payment exception to the overall limit of the liability? If you have an unforeseen dispute, especially if it has anything to do with changes to the goods and services as time goes on, does the contract allow you to vary the terms? If it is to do with any promises or assurance post-contract, it's worth looking to see if there is a variation provision so the parties can update the agreement accordingly. Next, is there a dispute resolution clause? Sometimes a contract will make clear what the parties are to do if there is a dispute, the form of dispute resolution, such as mediation or arbitration, and the time frame for that process to begin. It can sometimes help to de-escalate a dispute and promote an early resolution. Next is suspension. So can you or the other side suspend the contract until you resolve the problem? That's not always appropriate. You might be in the middle of providing services, and there might maybe business activities that are ongoing, but it's always good to check what it says about suspension. And then what is very much the nuclear option is termination. It's always good to know what are the grounds for termination in the contract. Given the nature of this provision, we strongly suggest getting legal advice on that point before exercising a right to terminate. The reason being because If it's not done correctly, it can mean that you inadvertently put yourself at risk and you're on the receiving end of a claim for damages through a breach of contract for wrongful termination claim. And then lastly, but not least, is now this is not strictly a clause, so I've slightly cheated here, but are you able to renegotiate the agreement with the other side in light of a potential problem or dispute? It could be changing the existing contract or potentially bringing one to an end and starting a new agreement. Sometimes simply picking up the phone to the other side to discuss a mutual issue can de-escalate the problem and encourage an amicable resolution. Now, I'm going to be turning it over to Ed, who will take us through the different types of dispute resolution.
Thank you, Jay. So if you're in a dispute or you want to clarify a legal position, then we can help you however you need. We can assist you with negotiating yourself, give you some legal advice to help you work out how to best win that with your own negotiations. We can engage in negotiations right on your behalf. And if that doesn't work or you want a more forthright approach, then we're very happy to assist you with that as well. So litigation will broadly have two main areas to cover. So court proceedings and then alternative dispute resolution, which is an umbrella for other means of avoiding or resolving disputes rather than going to court. So court proceedings, you can go to court for many disputes, money, enforcing a contract, injunctions. Litigation is, of course, always expensive and time consuming. It takes you away from managing your business. And it's not unusual for a claim to trial to take 1 to 2 years. Of course, we don't go to trial very often. We try and settle all disputes. I think 95% of disputes are settled before you get to trial. And we're always very conscious of the costs. So we always try to explain to you what the cost liability is of each stage, so you can budget for the legal fees you are incurring, and try and give you some control over that. For that reason, we do say litigation is a last resort. Therefore, we do try to resolve disputes for you before you end up in litigation. But if you need to go to litigation or proceedings are issued against you, then we can, of course, help you resolve those issues. Alternative dispute resolution is, well, exactly what it says. It's other ways of resolving disputes other than litigation. So broadly, the main areas are arbitration, expert determination, and mediation. Arbitration is either a contract or a lease, or the parties agree. Once a dispute arises, they can decide, right, okay, we want so and so person to arbitrate over this for us, decide this dispute for us. Arbitration is a binding forum, so you make your representations to the arbitrator, and then the arbitrator will decide the dispute. The parties can agree the process, so you can keep it simple and confined, and only X number of pages in the submissions, or it can be a full-blown arbitration, which eventually can be as almost as costly as going to court. The advantage, however, it is it's usually quicker, and you can choose an arbitrator between the parties who may be better than a judge. So particularly if you end up in the county court, you can sometimes find yourself before a family lawyer, and if you're dealing with a business dispute, actually sometimes they get it right, but there is a scope for an issue. Do you need someone who understands businesses to resolve that? If you've got a property issue, do you want a surveyor involved? If it's an accountancy issue, do you want an accountant? So, and that can help a dispute along if the person deciding the dispute, the arbitrator, actually is fully versed in the area. So similarly, expert determination is in some ways similar to arbitration, but you put your case together and give it to an expert, and that expert decides it. So say if you a property dispute, put the parties' written submissions in, or even oral submissions in, the surveyor decides it, off you go. Mediation is it's a non-binding forum, so you can go to mediation and then you can come out the other side not having agreed. There's no obligation to agree. It is a good way to vent people's concerns. Sometimes if people want their day in court as such, then they can go to mediation, say their piece, and quite often that actually is successful in resolving disputes in commercial level and in individual cases. And even if it doesn't work, I quite often find that cases that have gone to mediation can settle shortly afterwards because you've narrowed the issues in dispute. There's a cost to mediation, but it's a lot cheaper than going to court. And mediation is where you've got shuttle diplomacy going back and forth between the parties, rather than, and sometimes mediators do point out certain defects or strengths in cases, but mainly it's just trying to get the parties to understand their positions, and it is surprisingly effective. So specifically dealing with lease disputes, we'd look at three areas here. Firstly, what is the agreement? And then the types of disputes, and then how we resolve those disputes. So we're looking at what type of the agreement is. There's the broad categories I put on the screen here. So leases within the 1954 Act. That is an act which was put in place to after the Second World War to mean that if a tenant wants a new lease and the act applies, that tenant will have the property, a lease of the property it uses at a market rent, whatever that new market rent might be at the end of the lease. I find that clients, particularly startups, they're not really thinking much past the initial years. So they sign a lease for 5 years or 10 years or even shorter or longer, and don't really think about it. But what then happens is when you get to the end of the lease, the landlord can demand whatever rent he or she thinks you can get away with if you haven't got the benefit of the 1954 Act. So it is possible to contract out of the 1954 Act, and a lot of leases nowadays are contracted out. It's a relatively simple process of serving notices, and that loses you the benefit of the 1954 Act. Can be slightly cheaper on the rent, which is a benefit. Otherwise, licenses are quite common, particularly in startups, and the licenses are a lot easier. They're essentially a contract, just as you'll rent this space, and that's, you don't tend to have quite the obligations that you do in a lease. So leases can be drafted to include any provisions, but typically a lease of a building will require you to return the building back in good condition at the end of the lease, no matter what condition it was at the start. So if you are looking at taking space in a building, we can assist you to work out what's best for you and to avoid long-term liabilities at the end. I worked for a law firm in London called Halliwell's, which was a large firm. They took some space in a London office, and they then they're expanding, so they went to more space. The landlord turned up and presented them with £1 million bill for dilapidations. That was fought and successfully, and it turned out to be a £10,000 dilapidation claim. So I'm not saying we can magically reduce dilapidations claim in every cases, but what I am saying is dilapidations claims can be really large. So you sign a lease and thinking, oh yeah, just take the space, and then you end up producing yourself a massive liability at the end, or and sometimes actually during a lease you can be obliged to repair it. So it's worth working out what you take responsibility for, whether it's the whole building, a schedule of condition where you just say, oh, I'll return it in the same condition I got it, or just what's called an eggshell lease, which is just more typically in a license where you just take responsibility for a bit of light redecoration, possibly carpets and things like that. So there's something else is relevant, because there are other ways of occupying properties. As we say, here we've offer space for free for startups, but there can be other arrangements that also come into place. It's worth mentioning that if you enter into some arrangement which is simply exclusive use of a bit of property for a payment of rent, particularly if it's for a term of a certain period of time, then that automatically brings in the 1954 Act, and which can be beneficial for you as a tenant, and problematic as a landlord, and also problematic if you sublet or let someone else use a bit of your property. You can get yourself into difficulties in that way. So in terms of types of lease dispute, obviously the classic dispute is rent, whether a rent has been paid or not. The other one is landlord's obligations. You pay some money as a tenant for a property. Is the landlord complying with its side? Repair and dilapidations, well, I sort of dealt a lot with that earlier. It can be an extensive liability, which you need to think about when you enter into a lease or license. Use. So I've had quite a few cases where landlords have the clause at the tenancy agreement or license says you're allowed to use it for a particular purpose, and then for whatever reason you end up using it for some other purpose, and that can lead to the landlord being able to terminate the lease or making claims of damages or all sorts of things. And sharing possession as well. So quite often people run a number of different companies. Are you allowed to actually operate them from the same premises or not? Can it be a problem? Can the landlord terminate the lease if you do that? If you let a friend in there to occupy, can that cause you a problem? As I've identified, if that person is subletting, a couple of rooms in an office or something, can that cause you a problem when you come to leave? If that person then you fall out and that person then decides not to go. So in terms of dealing with lease disputes, they are contracts. So many of the same points we were talking about apply. However, there are two additional issues, which are that in a lease, obviously, is forfeiture. The lease can be terminated, and landlord's cost recovery. The landlord typically has the ability to recover its legal costs in a lease, and that can just add significant difficulties to a tenant because the tenant doesn't have the same ability to recover their costs except under the usual court rules. So how to resolve disputes? Well, I think first of all, you need to take early legal advice. We can assist you with negotiating. Sorry, I'll just sort out these. I think we'll stay there with the slides. Just how to resolve disputes. So there's early, take advice early, try and understand what the dispute is, see if you can knock it on the head at the start before costs rack up and you spend a lot of your business time dealing with them. You can negotiate directly with the other party. We can help you with that behind the scenes. We can help you draft emails and things like that to build your case or to make the point and make sure you don't cause yourself a problem by saying something you maybe shouldn't. Or we can engage in correspondence for you to try and help you there. If you're doing it or we're doing it, if you're negotiating a claim and if you want, you can mark the correspondence you don't want brought to the attention of the court without prejudice. So we quite often write two letters, one on the open basis saying we want, this is our open position, which is what we want the court to see if you end up before a court. And then on a without prejudice basis, we say, well, everything in that what we said is correct, but actually, tell you what, we'll resolve it in this way. And if you need us, we're here to take up the cudgels for you and fight your case before the courts or in other formats for you. Right, so on to the final slide. So our key takeaways. Disputes disrupt your business. We can help you try and limit or avoid that as best you can. But sometimes disputes are necessary if you need to hold your ground and you need to fight for something that is validly due. Clear contracts and leases at the outset can help avoid disputes. Quite often these documents are signed, put in a drawer, never seen again. But the number of disputes I deal with where people start off by agreeing something in an email or just orally, and then, as Jake has explained, it becomes very difficult and messy to do that. And the messier and more difficult it is, the more expensive it is to resolve a dispute. If you've got everything in a contract and there is a dispute, either they'll never go to trial because everyone knows what the position is, or you'll have a short 1 to 2 day trial. If you've got a complete mess of a situation, you could have a 2-week trial, and the legal costs there can be very significant. And finally, we're here, we understand business, and we try to work with you in a business focused way to resolve your disputes as best we can. So does anyone have any questions?
It's okay if you don't have anything for the moment. It's worth saying thank you very much for attending this WISE session. We do hope you found it helpful. And if you've got any follow-up queries, then please do get in touch with either myself or Ed. And it's a goodbye for now. Thank you.
Thank you for listening.